Welcome. My name is Bobby Jacob, and I'll be moderating today's program, The Supreme Court and Its Potential Role in the Presidential Election. I'll start out today's program with a quote that helps define what humanism means to us as members of the Ethical Humanist Society. Humanists are naturally committed to social justice as a prerequisite to peace and happiness for the greatest number, and see it as a moral failing to stand by while others are denied their civil and human rights. Humanistic social justice advocacy involves respect for the equality of all people, compassion for their dignity and welfare, and a conviction that positive change requires human intervention. And that is from the AmericanHumanist.org, Key Issues, Social Justice. At the EHS, our programs address a wide variety of topics, including current events, philosophy, arts and sciences, to name just a few. Today's presentation is part of our ongoing programming relating to politics. Today's speaker is Stephen Schwinn. Professor Schwinn teaches constitutional law, comparative constitutional law, human rights, and a specially designed legal writing class on civil rights at UIC Law. Steve is founding editor-in-chief of the American Constitution Society, Supreme Court Review, and founding co-editor of the Constitutional Law Prof blog. He is a longtime member of the American Constitution Society, Chicago Lawyers Chapter Board of Advisors. Steve regularly works with high school teachers and students on civics education and regularly speaks on issues related to constitutional law and public policy. Steve's writings have appeared in a variety of law reviews and other specialized publications. He regularly writes for the American Bar Association's Preview of United States Supreme Court Cases and is a frequent commenter on issues related to constitutional law and human rights. Please welcome Stephen Schwinn.
Thank you. It is a real pleasure and thrill and honor to be with you today. I want to thank you all for hosting me and giving us this opportunity to talk about these really important issues. So I'm just going to grab my notes and my coffee, the two most important things, and then we'll go get started. Okay. So what I thought we'd talk about today, if it's okay with you, and if you want to go in a different direction, I'm more than happy to do that, so just let me know. And if you have questions or comments as we go, please feel free to pipe in. That's perfectly fine. Questions or comments are great. As I tell my students, you can keep your complaints to yourself. Talk to me afterwards if you want. But what I thought we'd do is talk about a couple of cases that came down from the Supreme Court this term that will have and are having a determinate effect on the 2024 presidential election. And then to the extent that we have time and energy and interest in talking about some other kinds of related things that are going on at the court that impact not only this election but beyond, I'd like to introduce you to some of those ideas as well. Does that work for everybody? Okay. Can I just get a sense, I know this is an involved, engaged, educated group, but can I just get a sense of how, have you paid attention to what's going on at the Supreme Court? Yeah? Okay. Yeah. Like, how can you not, right? Okay, really big things at the Supreme Court. We have seen monumental seismic changes in this Supreme Court in the last couple of years and decades. Everything from overturning Roe versus Wade to reversing on affirmative action to dramatically expanding gun rights to dramatically expanding religious rights. And as we'll talk about today, fundamentally changing the separation of powers in ways that I think we really ought to be very deeply concerned about. But I'll tell you quite frankly, we're just not talking enough about it. And so I hope that this conversation will help us talk a little bit more about it and share some ideas with each other. As I said, I want to talk about two cases that came down from the Supreme Court this past year, and I'm going to give you some background and introduction to both of them, and then talk about how they're both having an effect on the election, one at a time. And then again, to the extent that we have time and energy, we'll spin off and talk about some related topics and things that are going on at the Supreme Court that impact some of the issues in the campaign. And I'm thinking about one in particular. I was watching a Trump rally the other day with a number of signs in the audience talking about the deep state and draining the swamp, right? This is a theme that we heard in Trump's first presidential election and the second presidential election, and now we're hearing it again in 2024. And I want to put some context around that for you and tell you how the Supreme Court is involved in that effort to drain the swamp, as Trump supporters say, what that means in terms of constitutional law and the separation of powers, and why we ought to be deeply concerned about it. So if we have time and energy, we can talk a little bit more about that. But let's start with the two big cases this term that touch on the presidential election in really deep and profound ways. The first one is called Trump versus Anderson. It's a case that came out of the state of Colorado dealing with Trump's qualification to be on the ballot in the first place. Have you all heard about this, the ballot access? A little bit? Okay, so I'm going to give you some background, and I'm going to say right out of the gate, I'm sorry if I'm giving you information that you already know, or is that is too simple. If it is, feel free just to tell me, kind of move along. We already know this. It's not a big deal, okay? And if not, then we can just keep talking. So I want to kind of roll back to the late 19th century to give you a little bit of context for what's going on in this case, Trump versus Anderson. After the Civil War, we, of course, enacted the 13th Amendment, right, which abolished slavery and involuntary servitude, except in cases of, for punishment of a crime as part of a criminal penalty. So we did the 13th Amendment. That, of course, didn't solve the problems that caused the Civil War in the first place. And so we then adopted in 1868 the 14th Amendment. Now here, I want to pause for a second on the 14th Amendment and give you some details, because this is what's at issue in this Trump versus Colorado case. Now, the part of the 14th Amendment that most of us are most familiar with is Section 1 of the 14th Amendment. Section 1 of the 14th Amendment does some really important things coming out of the Civil War that abolishing slavery alone was unable to do. So, for example, Section 1 of the 14th Amendment grants birthright citizenship. If you're born in the United States, you're a citizen of the United States, to overturn Dred Scott versus Hanford. It provides equal protection, a kind of measure of equality that states have to provide equal protection for their citizens, even former slaves. It provides due process. So before the state takes life, liberty, or property, the state has to provide due process of law, even to former slaves. And then finally, there's a kind of sweeping clause in the first section of the 14th Amendment called the Privileges or Immunities Clause that grants untold rights, individual fundamental privileges and immunities, or fundamental rights to freed slaves and everybody else. But the framers left it open for us to determine throughout the course of our history what these privileges or immunities were going to be. What are they going to, how big are they going to be? Well, it turned out the Supreme Court very early on gave a very narrow interpretation to the 14th Amendment in a couple of important different ways. And so we're kind of stuck with that today. But Section 1 is the portion of the 14th Amendment that many of us may be most familiar with. Now, in addition to Section 1, there's a section in the 14th Amendment called Section 5. Section 5 gives Congress the power to enforce the provisions in Section 1. What that means is that Congress, if it wants, can enact legislation that protects equal protection, due process, privileges or immunities, and even citizenship. Now, Congress doesn't have to enact legislation in order for those things to be operative, but Congress can if it wants, and Congress has enacted civil rights legislation, as we know, over our country's history pursuant to this provision in Section 5. Now, as it turns out, some of the big pieces of civil rights legislation were not enacted under Section 5 of the 14th Amendment, and that's just kind of a historical quirk. So if we think about Title VII of the Civil Rights Act of 1964, for example, that wasn't enacted under Section 5 of the 14th Amendment. That was enacted under Congress's authority, kind of surprisingly, under the Commerce Clause. Title IX, banning sex discrimination in education, is a spending provision. But nevertheless, Congress could, if it wanted to, enact certain civil rights legislation under Section 5 of the 14th Amendment. So now we have Section 1, with the substantive provisions of the 14th Amendment. Section 5, think of this as kind of a procedural provision of the 14th Amendment that allows Congress to authorize legislation to enforce Section 1. But there's a provision in the 14th Amendment that we haven't talked a lot about since the late 19th century. That's Section 3. Remember, the 14th Amendment came in response to the Civil War. One of the things that the framers were concerned about is having former Confederates serve in office after the Civil War, right? How crazy would that be, that Confederates who had seceded from the Union then would serve as officers in the Union or in their states as those states are reconstructed and brought back into the fold of the Union? It would be crazy, right? And the framers saw that and they said, look, anybody who served as an officer of the United States or a state and took an oath to uphold the Constitution, anybody who did that and then engaged in an insurrection against the United States, against the Constitution, anybody who falls into that class is barred from serving in an office in the future, okay? Now, this applied early on, but Congress very quickly wrote legislation that basically granted amnesty and immunity to former Confederates. And so Section 3 hadn't really been operative in any serious way, even immediately after the Civil War. And after the late 19th century, after the Reconstruction period, we basically forgot about Section 3. It's in the Constitution, but we basically forgot about it until January 6th. In the January 6th insurrection, people started to dust off their constitutions and discover, hey, there's this Section 3 that prohibits former people, officers, who swore an oath to the Constitution and engaged in an insurrection from serving as an officer. Wouldn't that apply to Trump and, in fact, a number of different people who engaged in the insurrection on January 6th? And a number of states said, yeah, it does. It does. In fact, about 35 different states started to move in the direction in one way or another of disqualifying Trump from the primary ballot in the Republican primary in the 2024 election based on his actions on and around January 6th. Now, I want to pause here for a second and just remind us, what were these actions on and around January 6th? Well, there were a number of different things that Trump and his supporters did on and around January 6th to overturn the 2020 election. January 6th itself, we're all familiar with, and Trump's speech and his action and lack of action on January 6th contributed to the events of January 6th and the attempt to overturn the vote count in the 2020 election. But there's a lot more behind the scenes. So for a long time, Trump and some of his legal team were devising a legal theory that they could strong-arm state legislatures who, in states that had voted for Biden, state legislatures unilaterally to overturn the votes in their states and certify their electoral votes for Trump. Now, the theory here, I'm going to get just a little technical on you. The theory here was called the independent state legislature theory. This theory draws on text in the Constitution that some say gives state legislatures and state legislatures alone the power to allocate their electoral votes in the Electoral College, even irrespective of the popular vote in their state. So in a state like Arizona, for example, whose popular vote went to Biden in the 2020 election, the theory would say that the state legislature could overturn that vote effectively and allocate the electoral votes to Trump instead of Biden. And so we saw the Trump team reach out to legislators in Michigan, in Arizona, in Georgia, and other states where the popular vote went to Biden, and therefore the electoral votes should go to Biden, but reaching out to those legislatures to overturn the electoral vote in their state and allocate their electoral votes to Trump instead of Biden. So that was one other effort that occurred long before January 6th and was in motion long before January 6th. Another effort that was related to that is that Trump and his team were communicating with the Department of Justice and high-level officials in the Department of Justice saying, hey, why don't you tell states that there were irregularities in their elections in the 2020 election, tell their state legislatures that there were irregularities in their election and that they either need to halt the certification of the electoral vote or certify the electoral vote for Trump, not Biden, in those states. Reaching out to the Department of Justice, which is supposed to be an independent institution in our government, and strong-arming justice officials to make those claims to state legislatures. So then there was that effort. And then finally, President Trump was reaching out to Vice President Pence, as we know, and trying to persuade Vice President Pence to hold up the electoral count on the theory that there were irregularities in the vote in some states, and that we really need to put a pause on this whole thing and let it work out at the state legislatures before we certify the vote. So all this was going on in the January 6th insurrection, leading up to the insurrection, and then on January 6th itself. So going back to Section 3 of the 14th Amendment, and talking about Trump being a potential insurrectionist, right, for all of these different reasons, and therefore disqualified from the ballot. Now, I told you there were efforts in about 35 states to disqualify Trump from the Republican primary ballot in the 2024 election. Most of those failed or fizzled out for one way or another, but 3 actually came to full fruition, and in 3 states, you had judgments by courts that said Trump was disqualified and could not appear on the ballot. One of those states is our very own Illinois. We had a lower court opinion that disqualified Trump from the ballot. Now, that didn't run its course in our state courts. Other things intervened, but nevertheless, we had a ruling. Another state was Maine that determined Trump would be disqualified from the the Republican primary ballot in that state. And then another state was Colorado. Now, Colorado went the furthest. The Colorado State Supreme Court actually ruled that under state election law and the 14th Amendment insurrection clause, Trump was ineligible to appear on the primary ballot in Colorado. Now, that obviously didn't sit well with Trump at all, right? That would have substantially affected his campaign, especially if other states were to follow suit. And so Trump challenged that and took the case to the Supreme Court. The Supreme Court put it on a fast track, heard oral arguments and got briefing lightning fast, and then issued a decision just months after it. All of this had transpired just months after the Colorado Supreme Court had handed down its ruling. And what the United States Supreme Court said unanimously, 9 justices said this, is that states cannot enforce Section 3 of the 14th Amendment. The theory was that if states were to enforce Section 3 of the 14th Amendment, you could potentially have a patchwork across the country, where some states would say that a candidate is qualified and other states would say that a candidate is disqualified, and they'd be going in different directions in a kind of hodgepodge sort of patchwork kind of way. All 9 justices agreed that we can't have that kind of system. Now, of course, what that ignores is we have that kind of system, right? That's the exact system that we have, a patchwork of different qualifications to appear on the ballot. Of course, states have different qualifications, but for some reason, Section 3 was different. And all 9 justices said, determining whether somebody is an insurrectionist is a little bit different in kind, and we don't want that sort of patchwork among different states in that sort of situation. 5 justices went so far as to say only Congress can enforce Section 3, and only Congress can enforce Section 3 by enacting legislation. Now, the reality of the time is that there's no way that Congress was going to enact legislation disqualifying Trump from the ballot. That simply wasn't going to happen, right? The politics in Congress just didn't line up to allow that to happen. And of course, the Supreme Court must have known that, the 5 justices who so ruled. What's interesting about this is they didn't have to say that. They didn't have to say only Congress can enforce Section 3. A lot of different people can enforce Section 3, most notably federal courts, right? Somebody, you or I, could file a claim in federal court, get a federal court ruling that Trump is disqualified as an insurrectionist, and take that up to the Supreme Court. The court said no, only Congress can do it. Now that's weird because courts can enforce, remember Section 1 of the 14th Amendment, courts can enforce Section 1 of the 14th Amendment whether Congress has enacted legislation or not. And so the court seemed to be carving out this special category for Section 3 situations where only Congress can enforce Section 3 of the 14th Amendment, and only by enacting legislation under its power under Section 5 of the 14th Amendment, with full knowledge that Congress was not going to be able to do that. In other words, with full knowledge that the court's ruling by 5 justices, that the court's ruling would shut the door to any future Section 3 claims anywhere, anytime in the 2024 presidential election. Now, just saying that tells you the impact of the Supreme Court on the 2024 election, right? Had the Supreme Court not ruled that way, we might have seen different efforts among different states if they allowed states to do as Illinois did or as Colorado did, for example. If they allowed that, we might have seen Trump disqualified in a number of different states around the country. But even if states weren't permitted to do that, if 5 justices didn't say that only Congress can enforce Section 3 and only through valid legislation, then we might have seen a number of federal court lawsuits challenging Trump's qualification, and some of them might have prevailed, right? And if it went all the way to the Supreme Court, who knows what might have happened? I think we can reasonably guess, but you never know, right? And so we might have seen a different political landscape entirely had the Supreme Court not ruled that way in Trump versus Colorado. Okay, that's one case I want to talk to you about. You know what? I think I'm just going to pause here for a second and I've given you a ton of information. Maybe you know it, maybe you don't. I don't know. But are there questions? Or we could wait until Q&A time, whatever you prefer. Yeah.
I wonder what the court's rationale was for that distinction. I mean, like, what was their rationale for federal courts not being able to enforce?
Yes, of course. Thank you. Yeah. So the question was, what was the court's rationale that only Congress can enforce Section 3 only by enacting valid legislation under Section 5? Well, I'll tell you, it was thin. What the court said was there is a Section 5 in the 14th Amendment that authorizes Congress to enforce the 14th Amendment. And so, therefore, and here's a kind of logical leap, right? Because Section 5 authorizes Congress to enforce the 14th Amendment, only Congress can enforce the 14th Amendment. Now, how it made that leap is still kind of a mystery to me, and I've spent a lot of time with this opinion. But there you have it. Okay, let's talk about the second big case. And I'm going to try to be as mindful of time as I can, but I got to tell you, I'm really lousy at keeping time. So if I start to run into a Q&A period, I hope you'll give me the hook. Okay, this is Trump versus the United States. So this is the case that we might be more familiar with. It's the immunity case. Now, I had already given you a little bit of background on January 6th and the different ways that Trump is alleged to have engaged in an insurrection, right? The events of January 6th themselves, pressure on Vice President Pence, pressure on state legislatures, pressure on Department of Justice. All of these things appeared in the special counsel's original indictment, and we'll talk a little bit more about that in a second. But those were all the allegations against Trump. And as we know, he was indicted in the D.C. federal court by special counsel Jack Smith, and everything that I had talked about was in the original indictment. Now, what Trump said was, look, I'm immune from criminal prosecution for acts that I took as president. Now here, I just want to pause and try to unpack this claim a little bit because it's a really rather extraordinary claim. What Trump was saying is, I now am a former president, and so I'm therefore subject to law like anybody else for behavior I engage in today. But as to behavior that I engaged in as president, I enjoy absolute categorical immunity from criminal prosecution. I can't be criminally prosecuted for that behavior. Trump had a number of different theories why he was categorically immune. But really, I think the one that ultimately stuck was, if a president is subject to criminal prosecution after they leave office, and future presidents know that they would be subject to criminal prosecution after they leave office, that's going to chill their decision-making while they're president, right? And you can think about that. If you were president and you knew, well, I might be subject to criminal prosecution after I leave office, that might temper the way you make decisions. It might influence the way you make decisions. It might not, you might not make decisions quite as aggressively or quickly as you might otherwise, because you know that those decisions might later be subject to criminal prosecution. Now, of course, the flaw in that reasoning, and you're all thinking this in your head, is, well, maybe that's not so bad that presidents would take a breath before they engage in illegal behavior, right? Maybe that's not such a bad thing. But this was Trump's theory of the case, and what he said is we ought to be categorically immune as former presidents from criminal prosecution for acts that we took during our presidency. Just kind of a, typical sort of, and here I don't mean to sound partisan or anti-Trump, but we saw this tactic time and time again from Trump, where it's kind of spaghetti on the wall legal approach, right? Let the courts sort it out, and then as they're sorting it out, drag your feet to drag out this litigation as long as you possibly can, in the hopes that it'll go away one way or another at some point in the future. We'll come back to that idea here in a second. And so this wasn't unusual for Trump. We had seen this strategy time and time again in litigation, both criminal and civil, relating to Trump in all kinds of different fora, in all kinds of different situations. And so this was par for the course. The lower courts rejected the claim, as anybody who was paying attention expected. It was a crazy claim, right? Well, the claim then went to the Supreme Court, and the Supreme Court reversed. The Supreme Court actually granted Trump pretty much everything that he asked for, but in a slightly different way. So I'm going to describe for you what the Supreme Court ruling said, and then I'll talk to you about practically what it did. So what the Supreme Court said was there are basically three kinds of immunities that a former president might enjoy from criminal processes. One immunity deals with the president's core constitutional powers, what the court called the president's exclusive and preclusive constitutional powers. And if you're thinking about different kinds of immunities, you might think about three different circles, right? And we'll talk about each one of those moving out. Here we're talking about the centermost circle at the core of the president's responsibilities, the center of the president's responsibilities. Here we're talking about things like the president's commander-in-chief power to direct troops on the battlefield, right? It's widely agreed that that power is at the core of the president's exclusive and preclusive power. What we mean by that is Congress can't direct how the president directs troops on the battlefield as commander-in-chief, okay? Congress has a lot of say in what the president does, but not in that. Here's another example. The pardon power. The president can grant pardons as part of the president's Article II powers in the Constitution. That's an exclusive and preclusive power that the president enjoys, meaning that Congress cannot interfere with it or regulate it. Congress can't tell the president that they can only grant pardons on Tuesdays, for example, or only grant pardons to particular kinds of people or crimes. Congress doesn't have that power. The pardon power is part of the president's core constitutional powers. Here's a third example. The president has some core constitutional powers over certain matters of foreign affairs, in particular recognizing foreign sovereignties, which turns out in today's world to be a pretty significant power. Recognizing or not foreign sovereignties on behalf of the United States is kind of a big deal today. And the president has that unique, exclusive, and preclusive power. Now, for those powers at the core of presidential authority, those exclusive and preclusive powers, the president is absolutely immune, categorically across the board, from criminal prosecution. A former president simply cannot be prosecuted for those acts, okay? Hold on to that idea. It has sweeping implications. Now, if we move out, right, the court talks about the president's outer perimeter of responsibilities under Article 2 of the Constitution. The president has a lot of these responsibilities. The president is charged with enforcing or executing the law, which comes with a huge deal of discretion, as we may have time to talk about. And that means that the president, almost everything the president does, right, is part of the president's outer perimeter of their power. And indeed, the Supreme Court has defined it as nearly everything the president does when they're the president. The president's a 24/7, 7 days a week, 365 days of the year office. It just doesn't, you don't kind of hop into the office and hop out. You never clock out as president, right? And so almost everything that the president does, maybe everything that the president does, we don't really know, is part of the president's outer perimeter. Now, for the outer perimeter of powers that the president has, what the court said is the president has at least presumptive immunity, which means it could be more than that. It could be absolute immunity. We just don't know. But what the court said is at least presumptive immunity means that a prosecution would have to show that a criminal indictment against a former president would not have an effect on the president's ability to be president, to fulfill their Article 2 responsibilities. Now, that's a pretty high bar, right? No effect on the president's ability to be president. Wow. That could be, as a practical matter, absolute immunity. As a legal matter, it might be absolute immunity. We just don't know. So now what we have is a core presidential responsibilities with absolute immunity, responsibilities in the outer perimeter of the office with at least presumptive immunity that may actually be absolute immunity. And now we've got the third ring. The third ring is presidential action taken in their purely private capacity that really has nothing to do with their office, purely private capacity. The president enjoys no immunity from criminal liability. So a former president actually could be prosecuted for actions and behaviors that are purely private and have nothing to do with the office. Here's the thing. The Supreme Court said that in proving this, a prosecution is going to be hamstrung in a couple of ways. The prosecution cannot inquire into the president's motives, for one. You can't ask about why the president was doing something. So if the president is taking a bribe for a pardon, which would seem like a corrupt act to many of us, right? What the court said is the prosecution and the court in a criminal case can't inquire into the president's motives. Now, if you can't inquire into the president's motives in a bribery situation, your bribery case goes away. There's no president could easily defend against a bribery indictment by simply saying, well, I had no intent of a quid pro quo with this exchange. And so by not being able to inquire into the president's motives, the court has sharply undercut a prosecutor's ability to prosecute a former president. But there's more. And the more is that a prosecution can't use a president's actions that would be immune in order to prosecute a president for actions for which they do not enjoy immunity. Let me give you an example of that. We talked about Trump communicating with Department of Justice officials, right? Trump communicating with Department of Justice officials for the purpose of pressuring them to pressure state legislatures to overturn the popular vote in those states. What the court said is, when Trump or any president communicates with their Department of Justice, that's an official act of the president at the core of their presidential authorities, communicating with high-level advisors, especially the Department of Justice. Well, that's what presidents do. That's at the core of their powers. The prosecution can't use any of those communications, or even the fact of those communications between the president and the Department of Justice in showing a criminal case for anything that Trump might have done on January 6th. That sharply undercuts the prosecution's ability to prosecute the president for January 6th. Now, some think that when you put all these pieces together, and I happen to be one of them, the dissent in the case happens to be another, Justice Sotomayor led the dissent in the case, that when you put the pieces together of this immunity, what you actually have is absolute presidential immunity, or at the very least, a roadmap for a president to create situations such that they will enjoy absolute immunity in the future. If they want to do a bribery for a pardon, for example, well, simply consult with your attorney general before you do it, right? And that's going to undercut the entire case. As Justice Sotomayor pointed out in her dissent, if the president wants to order in his commander-in-chief capacity, SEAL Team 6, to assassinate a political opponent, well, it appears that the president would be absolutely immune from that. Why? Because the commander-in-chief authority is at the core of the president's power, and we can't inquire into the president's motives. Wow, that's stunning. And that's probably right. It's really hard to read the opinion without coming to that conclusion. So we might say, all right, well, how does all this affect the election, right? Let's talk about that for a second. Oh, I forgot to mention one thing about the case. So kind of along the way, the majority issued its opinion, as I described it. Justice Thomas issued concurrence only for himself, and he went a little off script here. He talked about an issue that wasn't even briefed in the case, wasn't briefed, wasn't argued, never a part of the case. What Justice Thomas wrote is that Jack Smith was invalidly appointed as special counsel. Remember, Jack Smith brought the indictment in D.C., that Jack Smith was invalidly appointed as special counsel. There's no statutory authority for his appointment. Therefore, his appointment is invalid. Therefore, the entire indictment is invalid. And Trump is not indicted for that independent reason, having nothing to do with immunity. Again, this was completely off script. But hold on to that for a second. So, as this case was working its way, there are 4 cases against Trump that allege criminal wrongdoing, 2 in federal court, 2 in state court. What I want to do is just tell you how this ruling has impacted these 4 different cases and how it has impacted the 2024 presidential election. So first, the DC Circuit case alleging that Trump engaged in an insurrection on January 6th and the events leading up to January 6th. After the Supreme Court's ruling came down, Jack Smith went back to the drawing board and he reissued a new indictment, scrubbed the old indictment of all information that might relate to a president's core constitutional powers, those powers that the president would be immune from prosecution for, okay? Scrubbed it of that, and now is arguing at the district court, at the trial court, again, that this indictment is valid, even in light of the Supreme Court's ruling on immunity. There was a hearing just this past week on the issue, and Judge Chutkan, the judge presiding in the case, looks like she wants to move fairly quickly, but she's not going to be able to move before the election. And let me tell you why. Because whatever she rules on the indictment, right, Trump is immune or not immune, somebody's going to appeal. That appeal is going to take some time. And then they're going to appeal again to the Supreme Court. That's going to take some time. We're not going to have a ruling from the Supreme Court until next summer at the very earliest. And that's if things moved at lightning speed in that case. And so here you've got an indictment for a presidential candidate running in the 2024 election that he engaged in an insurrection, right? I mean, you can't even really say this without kind of like, what's going on? A 2024 candidate for the presidency under indictment for engaging in an insurrection, and we're not going to learn the facts of the case and whether he's guilty before the election. Wow. Now, it turns out we might learn a little bit more than what we already know about the case, because it looks like Judge Chutkan could hold a hearing on some of these immunity issues. And in that hearing, we could have some evidence come to light that maybe we don't know, or just sort of revisiting some old evidence. But we're not going to have anything like a criminal trial or a conviction before the election. which just seems like, in my view, a deep and profound impact on the 2024 election, that we could have a major party candidate running who's under indictment for insurrection, and we don't get a jury verdict in that case. That seems like a real disservice to we the voters. However that jury verdict were to come out, I would like to know before I cast my ballot, am I voting for or against an insurrectionist? Not a crazy question. There's a second case in federal court. This is in the Florida case, the Judge Cannon's case. And the case here, you might remember, is involving Trump's illegal possession of government papers, including classified government papers, after he left the White House. Remember those troves, those boxes that they found at Mar-a-Lago, and Trump really held up turning them over. There's an obstruction angle to this. He finally turned them over, and when he finally turned them over, and when the FBI raided Mar-a-Lago, they discovered a bunch of classified documents that were just kind of scattershot around these boxes. So they brought an indictment. Jack Smith, again, brought this indictment as well. And Judge Cannon, in the Florida case, has been slow-walking this case from the beginning. She's really let it back up and has issued some just jaw-dropping opinions in favor of Trump. There are some that are arguing now at the appellate court that the appellate court ought to order her off the case and assign it to a new judge because things have become so bad. I don't know that that's going to happen. But one thing that Cannon did recently, at lightning quick speed, even though she's been slow-walking everything else in this case, she just dismissed the entire case. She dismissed the entire case. And you know what? She dismissed it based on Jack Smith being improperly appointed as special counsel. Remember the Thomas dissent and the immunity ruling? She basically picked up the Thomas dissent, understood it as Thomas telegraphing to her what her ruling should be, and wrote that in a 90-plus page ruling that Jack Smith was invalidly appointed. Now, this is a jaw-dropping conclusion. Every other court to look at this issue, including the Supreme Court itself, has said that an independent or special counsel can be appointed by the same authority that Jack Smith was appointed by. Every court to look at this, including the Supreme Court. And so we might wonder what's going on here. Part of what's going on here is a movement in our law toward what's called the unitary executive theory. The unitary executive theory says that the president, as the head of the Article 2 branch of government and as the single only head of the Article 2 branch, has plenary authority of what goes on in the Article 2 branch. Now, just when I say this, I want to contrast it with the other branches of government so that you have some context for this. Congress doesn't have a single head. Congress has 535 heads, right? All the members of Congress. The courts don't have a single head. To the extent that you could say there's a head of the court system, you might say it's the Supreme Court with 9 justices. The president is the only head of a department of government who is a single person, and the executive power under the Constitution goes to the president. By this reckoning, the president and the president alone is responsible for everything in the executive branch, all the agencies, all the administration, all the execution and enforcement of law, irrespective of what Congress says and how Congress has structured those agencies. Now, here's the thing. The Supreme Court has been baby stepping in this direction toward a unitary executive theory for a couple of decades now. And it looks like it's going to take a big leap in coming years toward the unitary executive theory. What Cannon is drawing on is this unitary executive theory, and what she seems to be banking on is that there are now 5 or 6 justices on the Supreme Court that would go full-bore unitary executive. And you know what? She might be right. She might be right. And that they would go full-bore unitary executive, which means that only the president has authority to appoint somebody like a special counsel, and if the president didn't do it, there's no authority to do it, that the president has this kind of unilateral authority over the executive branch. So tying these different ideas together, I mentioned earlier, you know, the Trump campaign or the Trump rally that I was watching with some signs talking about the deep state. Well, that's what we're talking about, the administrative state. And what Trump has made part of his campaign, and if you've been paying attention to the Heritage Foundation, Project 2025, this is a core piece of Project 2025 as well, to promote the unitary executive so that the president has plenary authority over the administrative state, including the civil service. And if you were watching closely in the waning days of the Trump administration, you saw that Trump kind of lurched in this direction himself. He issued Schedule F, which exempted a whole class of thousands of new civil servants from ordinary civil service laws, from civil service protections from firing, and from civil service qualifications for hiring in the first place. And what this meant was that Trump and his political appointees would have plenary political control over a whole new class of thousands of previous civil servants in the executive branch. Now, that was a significant step, but it was only a first step in effecting a full-bore unitary executive. Trump and the Supreme Court have been working hand in hand, along with Project 2025 and the Heritage Foundation, in promoting this idea. And if it happens, it's going to be huge and significant. What it'll mean is that everything from the EPA to the EEOC to the Labor Department to the Securities and Exchange Commission, all the alphabet soup of administrative agencies will be politicized. That's breathtaking, but it looks like we could be moving in that direction. So that's an effect not only on the election, but on our politics. But let's go back to Judge Cannon's case. So she dismisses the case. Now, her dismissal is on appeal, but it won't get ruled on before the election, and certainly won't run its course through the Supreme Court before the election. So again, we have an instance of a major party candidate under indictment for what under any other circumstances would be a hugely significant crime against the United States. And we're not going to have an answer about whether they're guilty or not before the 2024 election. There are two other cases. They're in state court, one in New York. This is the hush money payment case, where Trump's alleged to have paid hush money to Stormy Daniels so that she would not reveal details of their alleged affair prior to the 2016 election. Judge Merchan and the court in New York, as we know, convicted Trump. He's a convicted criminal under New York law. But after the ruling came down granting immunity, Trump filed a motion in that case saying, I'm immune from this case too, under the immunity ruling that the Supreme Court handed down this summer. So up until just a couple of days ago, the New York court had been trying to figure out what to do with this. Judge Merchan had set things on schedule for later this month in September. But most recently, Merchan said, no, we're just going to put the whole thing off until after the election so that there's no appearance of politically motivated action in this case, not even the appearance of it. Right or wrong, the effect of that is to push off any further proceedings in the New York criminal case against President Trump. So we have a conviction in that case. We know he's been convicted by a jury of his peers, but we don't know anything else. We don't know if he's immune from that conviction. We don't know what his sentencing is going to be, and we don't know how that case is going to play out on appeal. So again, we have an instance of lack of information resulting from a Supreme Court decision. The fourth case is the Georgia state case for election interference in Georgia. Now, it turns out the Supreme Court had nothing to do with this case, thankfully. Here's one that it didn't have anything to do with. This case is proceeding on its own track at a very, very slow pace through the Georgia courts. We won't get a ruling on this case before the election either. That turns out not to have anything to do with the Supreme Court, but more to do with Fani Willis's alleged improprieties when she appointed a part of her team, her prosecution team that she had allegedly been having a relationship with. And so whether that raises an ethical problem is on appeal in the Georgia courts right now. And so we've got three major cases where, because of the Supreme Court, we're not going to have critical information about a major party candidate in the 2024 election. That's the kind of surface level effect that the Supreme Court has had on the 2024 election. But as we discussed, there's a much deeper effect here. The Supreme Court is talking to lower federal courts. They're talking to unitary executive theorists like Trump and like the Heritage Foundation and its Project 2025. And they're moving forward with this idea of unitary executive, which, if it goes forward in the 2024 election, could mark just a sea change in the way we do administrative law and law execution in the alphabet of agencies within the executive branch. It could be just huge. Okay? All right. Thank you. Thank you.
So we will get to the Q&A in just a second. We will have a short musical interlude. So while that musical interlude continues, we should be thinking about questions, and if online, entering them in the chat box. During the interlude, we'll be collecting contributions. Contributions can be made at our website, ethicalhumanistsociety.org/donate. A link will be posted in YouTube chat, and our in-person audience can scan posted QR codes, or use the basket which will be passed around. It is through our generosity that we show how meaningful the Sunday morning programs are. The suggested donation is $5. However, any amount that one is comfortable with is greatly appreciated. We appreciate all those who help sustain the society with their donations of time and money.
Thank you for that talk. It was very enlightening and scary. So I have a concern which deals with the actual elections and the results of the elections itself. I know it's in the future and you don't know what's going to happen, but the concern might be that Trump or any of the candidates could challenge any of the elections, and it goes up to Supreme Court at some point, and then Supreme Court decides, just like in the Bush versus Gore, who the president is going to be, despite whatever electorate has chosen. So how do you see this happening for 2024, 2025, and also is the only cure to this to be like a constitutional amendment to fix all of these things? Thank you.
Yeah, great question. Thank you very much. Are these questions getting picked up on YouTube?
Yes.
There. Okay. Good. Thanks. Yeah. Terrific question. So there is some indication that there may be some challenges to state election results in the 2024 election. We're seeing a lot of movement in Georgia, some in Arizona, some in other states that look like they're setting the stage to challenge the results if the results come down for Harris, not Trump. Now, I don't, quite frankly, given the way the politics are lining up, if Trump were to win the popular vote in these states, I don't expect that these mechanisms will challenge Trump's victory, but I think they will challenge Harris's victory. Now, some of these things are functions of state law, and so probably wouldn't get to the Supreme Court. I say that hesitantly because there may be things that are going on that could create a kind of federal, what we call a federal cause of action, so that the federal courts could get involved. But yeah, this is deeply concerning. It does look like some Trump supporters are setting the stage in some states to challenge a predicted Harris victory in those states. And if that happens, that could be deeply problematic. What's the solution to it? Well, so there have been some pushback to these efforts. And so, for example, in Georgia, folks have been talking out against some of the moves that Georgia officials have taken to kind of set the stage for these kinds of challenges and challenge their legality. And so maybe some of this could potentially get worked out even before the election. There could be lawsuits after the election that could work it out. There may be roles for state legislatures and Congress going forward, although I don't expect them to do anything in anticipation of the 2024 election. But learning lessons from 2020 and 2024, I would hope that state legislatures and Congress could start to enact legislation that would prevent the kinds of gaming that we're seeing. And then finally, I'll just tell you my own thoughts on this. If we're concerned about the state of our democracy and see one party or another threatening our very democracy, get out and vote. I mean, the best way to shut down what's going on in Georgia, what's going on in Arizona, what is likely to happen in other states if Harris wins in those states, the best way to do that is to, again, I don't want to sound too political about this, but give one party, give one candidate a significant win so that nobody can challenge it.
Thank you.
First of all, before I ask this question, I want to tell people that I'm not a Donald Trump fan. But when the Colorado case came up, I told my wife and my children, he says, this isn't going to go anywhere because, first of all, we have a policy in this country that you're innocent until proven guilty. And if doesn't go through some kind of a process, he's going to claim that he's not having due process. Of course, this is not the argument that played out, but I'm wondering what was wrong with my thinking.
Well, no, you're spot on, and we did hear that a lot from the Trump camp about lack of process with these Section 3 challenges. The idea was that, you remember the due process clause in the 14th Amendment. It's a due process-y kind of idea that if you're going to be deprived of something like that there's got to be some kind of due process that occurs before the government can deprive you of that. And that's a serious argument and one that I think we ought to engage with. And again, we heard a lot about that from the Trump team. Now, Section 3 itself is kind of funny because it doesn't provide for any process. It doesn't even tell us who can enforce it, which is a big problem and kind of what gave us this headache leading up to the Trump versus Anderson case. We just didn't know anything about Section 3 because we hadn't really used it. So we didn't know who could enforce it, who could not enforce it. We didn't know exactly what the standards were. We didn't know what insurrection meant, which offices it applied to exactly. And as you suggest, we didn't know if there's any due process, what is the due process that a person is entitled to before they're deprived of their place on the ballot. The court didn't engage with that. The Colorado Supreme Court, to my recollection, didn't seriously engage with that question. I think at that point, folks were taking it for granted that if there's a court ruling, it's the court process itself that would give due process to a person like Trump. And here's what I mean by that. As the challenge was working its way through the Colorado courts, and here you had Colorado voters suing the Secretary of State to keep Trump off the ballot, that Trump was allowed to present evidence in that case, and that there was an opportunity to challenge the disqualification under Section 3. Now, if Trump took advantage of that or didn't, that doesn't matter, but that the opportunity was available to him, I think, is the idea that protects any due process that he might have been entitled to. But again, the Supreme Court didn't engage that question, and so at the end of the day, we don't know it. And it doesn't strike me as off the wall to think that somebody would be entitled to due process, but what that process is then is an entirely different question. I want to return to where you started in saying that you don't want to present yourself as a Trump fan. When I talk about things like this, it's necessarily political because of the way our politics are today. I don't like to talk about it in political terms, and so what I tell my students is this, maybe you like some of the things that have happened at the Supreme Court, some of the things that we've talked about today, maybe you dislike them, but here's the thing. If you're really testing your commitment to the separation of powers in our system, think about whether your result maintains if we weren't talking about Trump, but we were talking about Biden, or if we weren't talking about Trump, but we were talking about Hillary Clinton, right? Would you still feel the same way? And I try to use that as my own guidepost for determining my own separation of powers commitments. And I try to urge my students to do the same so that we're not partisan about it. But I got to tell you, some of you may have heard some imagery about the idea that we've got an ordinary range of politics. Trump has pulled us so far away from that ordinary range of politics that it's almost impossible not to talk politically about him, which makes it really frustrating from my standpoint. And I apologize about that, but I just kind of feel like that's a reality.
I think this might sort of be part of that. When the January 6th stuff was happening, one of the things that I'm a long-time public policy person at the federal level, so I live in government agencies in alphabet soups. And one of the things that kind of worried me as that story was unfolding was the stories we were hearing about how the people around him just didn't do stuff he said because they knew it wasn't okay. And both in the Pentagon and on his staff, and like a bunch of people just sort of didn't do what he said because they knew it wasn't okay. And you and I as people are glad people didn't do things that weren't okay, but I, as somebody who appreciates laws and procedures and how it's supposed to work, when the president tells you to do the thing, you're supposed to do the thing, right? So I feel like the whole thing kind of challenges our understanding of what your fidelity is to, and I think I'm curious how the unitary executive sort of plays into that, where I'm the Attorney General and you come in to me and tell me about how you want to bribe the guy to do the thing, but now that you've told me you can't be held liable, but I think it's a terrible and bad thing, what do I do? If I quit, you just put a stoolie in who claps for you, and if I don't quit, I'm complicit in something I know is terrible. And so I'm just wondering what people of conscience and people who take this stuff seriously can do. What is your recourse when you're asked to do the thing? And that catapults me to, why doesn't Kamala Harris pull a Pence? Why doesn't Kamala Harris do what Trump wanted Pence to do? If Trump thought Pence could avoid certifying, why doesn't Kamala Harris? I mean, all these turning it around apply
right, exactly.
to Biden and Harris.
Yeah, for sure it does. And just on that last point, yeah, you're exactly right. If Harris were to do exactly what Trump did, everything that Trump and the Supreme Court have lined up for the presidency would apply with equal force to Harris.
And
she could overturn the election.
Right, but this is my point about what do people of conscience do? I don't think they do that because I don't think they think that's the right thing. And yet, if that's the rules of the game, should they do that? That's
question is way above my pay grade, but I'll give you my 2 cents on it. So first off, presidential immunity is a unique kind of thing. If the president is ordered, I mentioned, for example, the president ordering SEAL Team 6 to assassinate a political opponent. The president would almost certainly be immune from criminal prosecution for that, but SEAL Team 6 might not be, okay? And so there is that level of check. Now, if we start with that premise that those that report to the president would not enjoy the same immunity, and then we think about what their obligation is, well, their obligation probably is to behave lawfully, irrespective of the orders that they're getting from the president. And what that means in any particular circumstance, or it's going to involve some really tough questions, I think, for a lot of people in some circumstances. But if that's the kind of guidepost for behavior, I think that seems like a sensible one. And you're right, if that means that you have to resign other than engaging in illegal behavior and leave it to the next person who inevitably will engage in that illegal behavior, that's a really tough problem. I don't know what you do with that. We have seen that before with the Midnight Massacre in the Nixon administration. And we very well could see it again as we march toward this unitary executive. And I say that irrespective of who's in the presidency, because as you point out, if we set up a unitary executive, that's set up for Harris as well as it is for Trump, right? And the immunities that we've talked about, they apply equally to Harris as they will for Trump, at least in theory, and could engage in similar kinds of behavior, equally worrisome. Yeah, it's a really great question. Thank you.
I'm sure that's a lot of very good questions. I have a lot of them myself, but I'm going to stick with one here. Obviously, interpreting the Constitution, a couple hundred-century-old document, is going to be difficult no matter what.
Yeah.
But it does seem, and you've touched on this a bit, that... Or I could turn it up there. Anyway, but there seems to be a sea change here in terms of the present Supreme Court just making up new constitutional justifications out of whole cloth. And specifically, in the gun rights question in particular, that you have to look back to historical precedent at the time it was written, and once you start doing that, you can make up anything you want. I mean, that applied to like single-fire muskets that take several minutes to unload.
Yeah.
But now it somehow applies to AK-47s, and that's not inconsistent. So I guess, is there any limit to how the Supreme Court can basically make up justifications for the answers they want in the end?
Well, so the quick and pat answer is the Supreme Court says what the law is, so it can say what it wants. That's not at all satisfying, and I understand that. So let's drill a little bit deeper, and I'm really glad that you brought up gun rights, Second Amendment rights, because we had a case this term that I think really pressed the court on its approach to constitutional interpretation. I almost said originalism, but I hesitate, and I'll explain why. So this Supreme Court, and historically, at least in the last several decades, political conservatives have been very keen on an interpretive technique called originalism. There have been a lot of different forms of originalism, but the one that's in fashion today, and generally, says that in order to understand vague and indeterminate terms in the Constitution, what we need to do is understand how those terms were understood and used at and around the time of the framing, around the late 18th century for the main Constitution, or around the late 19th century for the Civil War, the Reconstruction Amendments that we talked about earlier. And if we understand the meaning of those words, the understanding of those words at the time, then we will understand how we should apply them today. Now, of course, things have changed today. We're not using muskets anymore, but we can apply, say, the originalists, the same principles that animated the Second Amendment originally to the reality of gun ownership and gun rights today. Something else is going on with individual rights, though, that doesn't, I think is not quite right to call it originalism. And let me describe what the court's done both in the gun rights case and in overturning Roe versus Wade. What the Supreme Court has said is that when we determine what fundamental rights exist today in 2024, we're going to look not at the original understanding of the language in the Constitution, or at least not only the original understanding, but we're going to look at our history and tradition. What the court says is, in the context of abortion rights, for example, we're going to look to our history and tradition to determine how the government over time has or has not regulated abortion. With gun rights, how the government over time, going all the way back, right, to the early colonies, even before Old English law, and then all the way up through the present time, how has the government regulated gun rights, okay, to determine how the government can regulate it or not today. Now, when the Supreme Court first articulated this test in the Second Amendment context, it did it with regard to a concealed carry law in New York. And what the court said was, there's not a history and tradition of regulating concealed carry, and therefore New York cannot regulate concealed carry under the Second Amendment, right? Again, drawing on history and tradition to arrive at that conclusion. Now, here's the thing. A case came to the court this term, it's called Rahimi, involving an individual who really liked to shoot guns and was under a domestic violence restraining order, in some ways related to his gun shooting. Under federal law, it's illegal for a person to possess guns if they're under a domestic violence restraining order at the state or local level. Well, he possessed guns while he was under this DV restraining order, and so was charged with violating federal law for possessing guns while under a DV restraining order. I say all this because if you start to think about history and tradition, you know where I'm going, right? We don't have a history and tradition of prohibiting individuals under a DV restraining order from possessing guns. Why don't we have that history and tradition? Well, because we barely have a history and tradition of DV restraining orders. If you go back and take the long view, I mean, for goodness sake, DV restraining orders protect everybody, of course, but if we're talking about in gender terms, they protect women a lot. We don't really have even a history and tradition of women enfranchisement until the 20th century, right? And so this case, in my view, presented the court with a real problem. How do you line up a history and tradition test with a current reality and understanding of domestic violence and gun possession in a domestic violence situation? And if we're applying history and tradition faithfully, doesn't that mean that the federal law that criminalizes gun possession for those under a DV restraining order is invalid? And if so, isn't that just kind of a shocking and breathtaking conclusion, right? Well, I think the court saw the handwriting on the wall, and so it didn't back off its history and tradition approach, but what it said was, we're going to look at history and tradition at a more abstract level. What we're going to say, yeah, this is great, right? What we're going to say is, history and tradition doesn't mean do we have a history and tradition of restraining people with DV restraining orders from gun possession, but do we have a history and tradition of preventing generally violent people from possessing guns, right? And dealing with the question at a higher level of abstraction. And the court said, yes, we do. And so therefore, this law is upheld. Now, the Rahimi case tells me this is a court that's spitballing. I mean, give me a break, right? History and tradition, and we could spend another hour or two on history and tradition in the case that overturned Roe versus Wade. It's utterly bananas. And it looks to me like it's a bunch of amateur historians literally spitballing in their chambers in the Supreme Court. It's embarrassing. But there you have it. And why can the Supreme Court do it? Because it gets to say what the law is.
In other words, they are just making it up.
They are just making it up. Now, I don't want to sound too pessimistic about this. What I tell my students is the fact that we're dealing with history and tradition didn't fall from the sky. This is a decades-long effort on the part of political conservatives to embed originalism and history and tradition into our constitutional interpretation. This goes back to the 80s, even before, to do this in order to achieve, again, I don't mean to sound political here, but in order to achieve a politically conservative outcome at the Supreme Court. And then moreover, to get justices on the Supreme Court that are going to interpret and vote that way. And they did it. This is what I tell my students. That's been a decades-long democratic effort at every level of government to do that. If they can do it, we can too.
Thanks for your talk. My question, I think, is building off of what you were just talking about, in terms of like the originalism or history and tradition and other kind of rationales or like underlying philosophies, I was just wondering where the immunity decision fits into that, if that is like motivated by some underlying philosophy, or if it's just like about Trump and trying to get him off.
What a great question. I would say there's not, I was going to say there's not a lot of originalism. I'm not sure there's any originalism in the Trump immunity ruling. What the court seems to be doing in that ruling is almost political philosophy. It's saying, okay, so we live in this separation of powers system. We've got a president who, as a single person, sits ahead of the Article 2 branch. If they know they're going to be subject to criminal liability when they leave office, that's going to hinder their ability to be president. We don't want that. And so therefore, we're going to grant immunity. It's that sort of syllogism that's animating them. And to me, well, I mean, there's no, that's the analysis. That's what's in the opinion. There's not anything more. And so is it originalism? No. Is it history and tradition? No, not really. It's just kind of 5 people sitting back and thinking about what the Constitution should be. We might come to a different conclusion, right? We have more than 5 people here. We could come up with our own immunities or not.
So my question gets to and you may not be prepared to answer this, but just to think about, you know, this talk has been very informative, and I appreciate it. And there's a lot of insight that, even though I follow these things, I still sort of follow them superficially, and the depth has been really great. But when I sit and listen to this, my head starts spinning. And I think back to the conversations that I have. I'm fairly actively involved, and I talk to people, and I talk to intelligent people and caring people, and there is a certain disengagement, a certain disenfranchisement of democracy itself. And I think I would ask, do we as a country still actually believe in democracy? You know, people, you know, they know they should go out to vote, but voter participation is pathetic. People sit there and rant and complain about, and in a very cynical way, about politicians. They dismiss them, they don't trust them, whatever. And then I ask, well, do you know who your local school board is? People don't even know the distinction between their alderman and their state representative. And these are people that have we've just sort of given up on it. And to me, I think there's a larger issue. We can talk about an originalism and the fairly sophisticated effort for the conservatives to move in this direction. But would that even be possible if we actually cared about democracy enough so that we were committed to it?
Whew. Wow. Another fantastic question. Again, way above my pay grade. I don't think there's a panacea. I don't think there's a single answer to that problem. But for my own money, I'll tell you what I do. Civic engagement, civic education, I think is hugely important. And that's why I was so wildly thrilled and honored to get the invitation to talk to you all today. Having discussions like this in formal settings or informal settings, or even around your kitchen table, I think is just so critical in revitalizing democracy. And I guess what I would urge us all to do is make a commitment to have those conversations on a more regular basis with our friends, our neighbors, our colleagues, whomever, and just talk about these things and help educate each other about what's going on in our democracy. I feel like that's so critical. Of course, there are a lot of other things. That's just my own thing. But I do think that's an important part of it. Yeah, thank you. Really good question.
Just want to squeeze in one of the YouTube questions. Why do you think Jack Smith did not try to get an indictment against Trump as an insurrectionist? I'm going to understand the question as for insurrection itself as opposed to the other things that he was charged for. Yeah. Well, so the indictment, it comes pretty close. I mean, we can say basically that the indictment is for a number of illegalities involved in the insurrection and trying to reverse the 2020 election. The new indictment, the
the second version of the indictment that came down after the Trump immunity ruling is aggressive as well, equally aggressive. It simply omits quite a bit of information that was in the earlier indictment because of the Trump immunity ruling. So Jack Smith is going ahead with this. Another way to understand the question is, why did Jack Smith take so long in issuing the indictment? Now, the Supreme Court itself sat on this case for a long, long time, longer than many people thought was reasonable, before it issued its immunity decision. And as a result of the Supreme Court dragging its feet, it sort of set back all the future legal proceedings, ensuring that we're not going to get an answer to these questions before the 2024 election. But if you go before the Supreme Court got the case, right, Jack Smith took a long, long time. Department of Justice took a long, long time before it issued the very first indictment in the first place. And so we might say, what's that about, right? We understand it's going to take some time to issue an indictment in a case like this to make sure that it's airtight. I get that. But for goodness sake, they took a long time before they got this indictment out. And so that also set things back and created a situation where we just don't have an answer before the 2024 election.
Right. Well, I get in one more question. So how did the Supreme Court answer Sonia Sotomayor's dissent about Navy SEAL? Like, if the president doesn't want somebody to act the way they are doing, they could just fire them, not just fire them off, they could just fire them, right? So how did they answer that? I mean, we are depending on norms which are not being followed, right?
So, yeah, it's a really good question. They didn't directly answer it, and so I'm going to try to channel the majority in the case and see what they might have said. It turns out there's a footnote in the majority decision that says, while a prosecutor cannot use evidence of a president's behavior that would otherwise be immune, and while the prosecutor cannot scrutinize the president's thinking or purpose in making certain decisions, that a prosecutor can rely on publicly available information about events that, were involved with the president's decision-making. It's not clear exactly what that means, but what it might mean is that in the case of, for example, the president ordering SEAL Team 6 to assassinate a political opponent, that a prosecutor couldn't rely on the communication between the president and SEAL Team 6 because that's part of the commander-in-chief authority. But to the extent that there's publicly available information in the New York Times, for example, that reported on the president doing that, or something like that, they could rely on that. Now, there are other legal problems with relying on that kind of information, but the footnote seemed to open the door, at least potentially open the door, to allowing that kind of evidence in. And so I think what the Supreme Court would say is, look, the Sotomayor's dissent is just making too much of this. When it actually plays out, this isn't going to be a problem. It's not going to be a problem because there might be other evidence a prosecutor could use. It might not be a problem because, as we talked about earlier, those who report to the president are still not immune, right? And so they've got a kind of baked-in disincentive from engaging in illegal behavior, even at the order of the president. And so their thinking might be, as a practical matter, it's not going to happen in the first place. Even if it does, there can still be an indictment and conviction.
So Charlie's worried about people's engagement with democracy, and I'm kind of worried about the Supreme Court as an institution and its credibility.
Yeah.
And I'm curious if you have what your thoughts are about the efforts to create some kind of a code of conduct that's been floated now, and whether it's too late to make a difference. The vetting process, like the whole process, and the idea of when they need to recuse themselves from cases and things like that. Like, how do we hold them to account for the kind of standards that we want for people?
Yeah, great, really good question. So, I mean, there are models around the world of holding high court justices to account in different ways, from term limits to rotating benches to different appointment methods that will assure a more ideologically diverse court. There are a lot of models that we could draw on around the world, some really exciting things happening in other constitutional democracies. What Chief Justice Roberts has said is that he views it as a separation of powers problem if Congress were to try to impose some of those things on the court, like a code of ethics. I don't think he's right on that, and I'll tell you why. Congress has a tremendous amount of power over the court. Congress gets to set the size of the court. It gets to tell the court what its appellate jurisdiction is going to be. It funds or defunds the court. Congress has a tremendous amount of power over the court. For the court to say that Congress could not impose a code of ethics on the court, I think is stunning in light of the amount of power that Congress already has. To me, the greater power, for example, to fund the court in the first place, right, includes the lesser power to impose a judicial code of conduct. I don't think it's going to happen. I just don't think there's the political will to make it happen. And to the extent there is, the court's going to say it's a separation of powers problem. And you know what? Who gets to decide? The court. So that's kind of a bleak picture. But there are exciting models around the world. It's just getting the political will to explore them.
We'll go ahead and do some announcements.
All right, okay, all right, thank you.
Thanks, Steve, for your talk. Thanks for answering all our questions. Getting some feedback.